everybody, excited utterance here. My name's Hella, and we are going to revisit a case that we've only covered a couple of times. It happened in April last year. Oops, hang on. April last year, and my cats are going nuts back there. This is kind of disturbing. Well, it's pretty disturbing, but it's gone a bit nuts since then. You would have thought it would have been pretty clear cut. This woman is guilty, but it's got a bit interesting. Now, let me remind you all, before we all discuss it, I just want to remind you of the footage because it went really viral at the time. This happened in Michigan. And then I will say hi to everybody. So let me add this to stage. Okay, here we go. Do you all remember this? Boom. Bam. Kablam. Yeah, I know, Kat. All right, so that was one side of it. Oh. And I'll show you also. Two seconds. I'm going to my own Twitter because I posted something else. Yeah, I know, Kat. Why are you whining so much? Jeez. Let's share this tab instead. Cool. All right. Do you remember this version of it? And it's got a little bit of extra at the beginning. Watch this. Brum. Blam! Kablamo! And it's got this bit at the end. See the big hole that was left in the wall? Yeah. Yep. Okay, so that's what we're talking about today. Hey, Emilsland. I saw it in court and I was fuming. This is pretty anger-inducing stuff. This is a bit of a nasty case. And I ain't about to start an innocence brigade for this lady. No, sorry, Bob. But it's actually turned into an interesting legal case because you would think it's really clear cut. She's just a drunk driver, but there's actually more to it. Wait till you hear, and we're going to get into it today. Okay, Cats, can you stop it? Righto. I just remember how bonkers her arraignment was. Oh, her arraignment was nuts. There were family members who were just like yelling across the room, and also they were on the Zoom feed and they were yelling at her, and it just people talking over one another. It was really crazy. Yeah. I hope you didn't like that wall. No. We did another stream after the arraignment, and that was, sadly, it was showing some body cam that had what was on the other side of that wall was a kid's birthday party. What could be worse than crashing through a wall into a kid's birthday party? That's what she crashed into. And unfortunately, 2 little children lost their lives as part of that accident. Now, she was apparently invited to that birthday party. She was on her way to that birthday party. So, well, she arrived. She made an entrance. Yep. Wow. So, anyway, okay, so what we're going to do is we're going to watch another bit of news footage, and we're going to get a little bit more context around this. So let's go. Before we go to her most recent hearing, I want to just give anyone who hasn't seen any of this before a little bit more context first. So let's go. Oh, hang on a minute. Can you hear that? I may have to bring it in again. I've got a little note come up on my screen saying that you can't hear audio, so I'll just have to make sure that you can. Can you hear that?
Stomach-turning footage after Marshella Chidster allegedly smashed her car into the Swan Boat Club in Monroe County back in April. 2 kids killed, 9 more hurt. She had a blood alcohol content of 0.18 plus a history of seizures. Her attorney has been saying all along she was told by a doctor she was allowed to drive when she says she had a seizure-like event that caused the crash.
My reaction is, there we go.
Attorney Bill Calovis and his client getting a potential big break after a story that ran here on Fox 2 in September.
She's watching the news, my client, and she texts me.
This bit
and says, my Dr. Garg has been arrested, and there's multiple counts of felonies.
We were there when Taylor police raided Dr. Ram Garg's office, facing 35 charges for running a criminal enterprise where he allegedly prescribed painkillers to thousands of patients who did not need them.
She was under his care.
Absolutely.
He was prescribing pills.
Absolutely.
And he had told her that it was okay to drive.
Right.
Now Garg is taking the Fifth Amendment, remaining silent in court, so attorney Calovis can't call him to testify. Calovis filed a motion to halt Chidster's case for now. This whole connection and Garg's tainted name could bolster her claims of a medical event after all. But there is still that high BAC of 0.108. Calovis says this.
I think everybody's going to be really surprised, as I predicted with Dr. Garg. Everyone's going to be really surprised. Don't rush to judgment. Let everything come out.
Okay, yeah, right. So no, we won't rush to judgment. Okay, so no, we won't rush to judgment, but did everyone see this video? So this came out at her probable cause hearing, I think it was. Guys, regardless of whether her doctor was running a pill mill or what, this is her on the day getting into her car, getting ready to go to this party. And so she's clearly making the decision to go and drive to this party. And just watch this. Just watch this. This is so bad. This didn't come out till a few months later, right? I remember watching this, and David actually went to this hearing. Our lawyer friend David went to this hearing, and he was just like, you have got to see this to believe it. Look at her stumbling about. What? Are you kidding me? Look at stop. Oh my God. And then, okay, let her walk down the driveway. Jesus Christ. There's more. Oh, there's more. This bit. Okay, it takes a...
What view is this, deputy or detective? Sorry.
That's
So
her
this is
car
the camera
there.
across the street on the bar.
Oh, but Ginny, she said she was having a seizure. You have got to see this bit. Takes a minute. Just give it a sec. I don't want to fast forward because I don't want to accidentally like show you what happens. The little kitty cat comes out at one point though. Oh, there she is. Hang on. Is she walking? Oh, no, no, no. Oh, there's a little kitty cat. See? Meow. Is it? Oh, yes, it is. Or is it a dog? Are dogs and cats just allowed to like run around with no like fencing? We gotta have our animals like fenced up. Oh, okay. I probably can go forward 10 seconds. She's only just coming out of the house. There she is. It does take her a while to walk. There she goes. There she goes. And at this point, she's deciding to get in the car because she's got a birthday party to get to. She's probably late, so she's like, I'm gonna go pretty fast. Always surprises me when people go around to that side of the car because, you know, in our country we go to this side of the car. Has she got there? Zach Gallery, how are you? Okay, watch this carefully, Zach Gallery. There's more than a scintilla of evidence against this lady. Oh, wait. Ready? Ready? What the fuck? She didn't even notice. And did you see the cloud of dust as she motors down the road? What? Okay, so after what? Hang on. Okay, so after fleeing the scene of an accident where she rear-ended the parked car of her neighbor, Marshella Chidster allegedly drove approximately 500 feet and plowed into the side of the Swan Boat Club, killing 2 children. It was only 500 feet from her house to the Swan Boat Club. Well, she could have stumbled. Really? It was only 500 feet? Okay. Okay, that's a shame. A big shame, to put it mildly. All right, now get this. There's more. There's more. Now, also, this is really the nail in her coffin. So, on the day of the incident, she was stupid enough to talk to cops, as you do. And this is after everything happened, right? After, oops, hang on. After,
I don't.
Okay.
hang on. So after all the kids are sort of scraped off the floor and things like that, she is talking to the cops from the cop car, and look what she says.
Once you got to the parking lot, you don't remember anything? I don't. Okay. Okay. I think that's all the questions I have for you now. Deputy Schmidt's gonna take me over from here, okay? Is there, so on a scale of 0 to 10. 0 being like you're stone cold sober, you can drive perfectly. 10 being you're passed out drunk. Where do you think you're at right now?
7.
A 7? Okay. Do you think you're okay to drive?
I wouldn't want to drive.
You wouldn't let you drive?
No.
Okay. Okay, just give me 1 second, okay? Sorry, my phone's ringing. I think it's gonna be my boss. I apologize.
Are you serious? She said that after the accident to the police. She said she didn't think she was okay to drive, and then she giggled. Oh my God, her attorney has some work to do. Her attorney has a lot of work to do. Jesus Christ. Okay, now, let's talk about her attorney. Her attorney's name is Mr. Clovis. Mr. Clovis. And we're about to see him in court. But he was stupid enough to let her talk to the press. Right? Yeah, smart, huh? Very smart. So she did a 2 to 3 minute press interview. Well, that's all that ended up on TV until because he was sitting next to her, until he was like, maybe you shouldn't answer that. So let's have a look. Let's have a quick look at that. Where is it? I've got a big list here. Let me see. Oh, hang on. Dolly's here.
Hey.
Hello. Have you seen all of this?
Just a couple minutes.
I'm just trying to find because I've got a big list of things here. So where is it? Marshella talks. I've got Marshella Chister's attorney responds, and then I've also. Can you stop it, cats? I hear you. I hear you, cats. How you been anyway?
Oh, peachy keen. How about you?
Yeah, all right. Oh, here we go.
Time we are hearing from the driver charged in the Swan Boat Club tragedy.
She talked to the
Chidster,
press.
telling us her version of what happened the day she drove her SUV straight into that club. The surveillance video capturing the SUV heading toward the building before it crashed into a birthday party going inside. 2 young children, a brother and sister, were killed. Well, tonight, Chidster telling 7 News Detroit reporter Ruta Olsonida she does not remember what happened behind the wheel.
Why did you decide to sit down with us?
I'm
Good
wanted
question.
to just let people know, that I'm so very, very disturbed about the situation.
Very bad answer.
I don't remember what happened. I can only say that I've been praying for everyone that's been injured.
The driver charged in the Swan Boat Club tragedy, 66-year-old Marshella Chidster, sat down with me at her home just feet from the boat club to discuss what happened behind the wheel. On April 20th, prosecutors say Marshella was drunk and drove her car into the boat club, killing siblings Zane and Alana Phillips, injuring over a dozen people who were all attending a children's birthday party. She's charged with second-degree murder and operating under the influence causing death. Marshella is a longtime member of the club.
I would never, ever do anything intentional. Never. I mean, that's just...
Not
just
intentional.
Intentional,
Especially
huh?
to a boat club that I love so much, and I have family and friends there.
Marshella claims
you
she
for
doesn't
real?
remember anything due to her medical
Not
conditions, which
intentional.
include neuropathy and heart problems.
Beat me to it.
She also says she has a history of seizures, and her memory goes out during her episodes, which is what she says believes happened that day.
I think I had a seizure. I think that the same thing that my husband said that I did when I have a seizure is just go straight. And I think when I got in the car, that's what happened. I just had the seizure and probably put my foot on the accelerator and crashed into the building.
The prosecution disagrees, as made clear in her arraignment a few weeks ago.
There was a preliminary breath test done which indicated that her blood alcohol level was significantly over the legal limit.
I have a perfect record. I don't even have a parking ticket. I don't have any kind of
That's a common thing to say, right?
DUI or
Well, you do now.
speeding ticket.
I wanted to ask
Now you
why
do.
she got behind the wheel that day, about her alcohol use, but when I tried,
April 20th. Just tell me about your entire day.
I don't
and
like
what
this
you did.
conversation.
but were interrupted by her attorney, who says the truth will come out in court and that she
That's it.
cannot speak to
That's
things
enough.
she doesn't remember.
I want strict
Ah,
facts.
you're a good man.
Marshella posted her $1.5
You
million
shouldn't
bond
have let
3
her talk
weeks
at
ago
all.
and remains at home with an
Idiot.
ankle monitor.
No, he's defending her
That's a
alcohol
point
use.
the family of the victims is furious about, and they are still dealing with the devastation of knowing they will never see their 2 children again.
We honestly still can't believe that she's still free.
Marshella is due back in court in June for a preliminary exam where a judge
she
will
can't
decide
drink.
if there is enough evidence for her to stand trial. In Berlin Township, I'm Ruta Olsenaida, 7 News Detroit.
All right, thank you so much, Ruta.
I am. Oh, hello.
It changed video.
It's very annoying.
It's at
Anyway.
22.
Yeah. 22. I am just shocked that this attorney let her talk to the press at all.
Well,
Like-
the town apparently hates her.
And that changed it?
Well, Mavka's here, good.
Hey, Mavka, imagine how she is going to enter the courtroom.
Like the Kool-Aid guy. Oh, I had that on my soundboard. I had the, oh yeah.
I just can't even fathom. Like, okay, so her defense at the moment is that she had a seizure and also that they can't prove what her blood alcohol level was.
Ah.
Yeah. So this Mr. Clovis, he's trying to get the blood alcohol reading thrown out. So this, what the most recent hearing we're about to watch now, and you can see how good of a job he did of that. So let's have a look. Cats, you need to behave. Yeah. All right. So where are we? Most recent hearing. And we're on.
Right. That is sum and substance is what you suspect.
Oh, no. Start at the beginning. There we go.
All rise. The Honorable Circuit Court for the County of Monroe in the State of Michigan. is
Yes, she is on bond.
Circuit Judge Daniel
I'm glad her arm's doing better.
presiding. You may be seated.
Top of 11, people of the state of Michigan versus Marshella Chidster.
All right. Well, we are here on a couple of motions, and the question is, why are we here on a couple of motions?
Whoa, is that Steve Gosney's
So
dad?
the motion deadline was 9/13. Mr. Clovis filed a request for an adjournment. I adjourned it to 11/8. 4 motions were then
I
filed.
bet he
almost
also
a
likes a
month
sidecar.
late. And now I have 2 motions filed 2 months after the motion deadline. One is framed as a motion in limine. That's fair. There's no deadline on those.
What?
Neither raise an issue
Stop
that were not known about months and months ago. So what's the reasonable cause for hearing this 2 months after the motion deadline, Mr. Clovis?
With regard to the toxicology,
I'm bad at my job.
We've retained an expert that will be testifying. In reviewing recently, the last couple weeks, thereafouts, with the expert and what took place during the preliminary examination, and then further looking at these records that were recently provided to me, my experts alerted me to a couple issues with regard to the toxicology, the foundation, and the reliability of the blood testing that was done that is going to be wanted to be admitted by the prosecution. So I could not file that earlier, and you have 2 counts, of course, of second-degree murder and capital offenses. Motions, why I respect deadlines, motions could be brought up during trial to protect someone's right to a fair trial and liberty and freedom. And so this isn't, of course, a civil case.
Okay, easy, Braveheart.
That deadlines are deadlines and evidence isn't in, or defaults are given, or dismissals are given for sanctions.
All right, so you told me there's a reasonable cause for the one motion.
What's
What
going on
about
with the
other?
captions?
We filed it, they have to lay the foundation with regard to private property, or is it open to the public? Judge, that's certainly, if you want to treat that as a in limine.
That's so weird. That's not the same.
This is the part of the show.
That's one of
Do
the-
I have in my teeth?
So
I'm
at
kind
least
of
I want to
adjusting,
put
making
everybody
sure.
on notice, Your Honor.
All right, we'll go ahead and argue the second one.
Right,
about
we're turning them off.
The public property.
Aw, chicken was so moist.
The property, I went down.
No,
to,
leave 'em on.
The clerk's office.
I want to hear about the moist
supervisor,
chicken.
And this area is private property, membership only. Public
Probably
not
do it
allowed,
better.
No trespass. It's not a Burger King or McDonald's or Taco Bell that somebody's driving in that's open to the public. This is
Wasn't
completely private.
trespassing. She was just in and out.
The elements also, I'm sorry, during the preliminary examination, which I've attached to the
She's a member anyway.
the
Exactly.
preliminary examination, that it's
She
private
paid her
property.
dues.
The officer testified it's private property. There's no question about it. Nobody said that, yes, it's open to the public. You can't leave your car there, you can't drive there, it's membership only.
I'll say you can't.
No, you're not supposed to drive there.
Assessor
You aren't supposed to
for
leave your
Berlin
car there
Township,
either.
and also talked to the supervisor of Berlin Township. She confirmed it with me. She gave me a little map.
Of course, she asked to speak with the
with regard
supervisor.
to it, and said that is all private. The county, the city doesn't take care of that area, doesn't take care of the road. The people that live there are the ones that take care of that little tiny private road. But more importantly, is the parking lot itself is private. It's not a party store that's open to the public.
Okay, I think we established that.
Okay, Judge, thank you. And that's my motion.
Mr. Lorraine?
That, just, if I may, Judge, that would certainly apply to all of the offenses that says operating a vehicle, causing death while, under a certain amount of alcohol,
I understand.
causing death, and it would apply to all of those. Thank
Mr.
you.
Lorraine?
Thank you, Judge. The statute's clear, Judge, that it's areas that, not just public roads or parking lots, it's areas generally accessible to the public. I think this meets that clearly. As an officer of the court, I was able to drive back there and get to the Swan Boat Club. Every member of the Swan Boat Club does not live in the plat that Mr. Kolobus is talking about. There are members who live out in other portions of the county. One of our witnesses is a person who doesn't live within Branch Hall Road or the surrounding roads, that is a member of the boat club and generally attends there. Therefore, its very existence and the fact that they allow members that don't live there shows that it's generally accessible. People in their response cited the Ray case, which is kind of the nth degree generally accessible case in the state of Michigan, that says that all of our driveways are considered generally accessible. Those are clearly private property, not open to the public.
Okay, what has this got to do with anything? I think he's trying to argue one of the charges, and one of the charges has to do with driving on a piece of property which is publicly accessible, right? And causing grievous bodily harm or death in an area which is publicly accessible. So I think he's trying to argue that, and he's trying to say it's not an area that's publicly accessible, it's private property, right? And so, okay, he's trying to say no, it's not public property, it's private property, it's members only. And so the state's all like, no, it's a car park. So I could get into there, people can bring their guests there. So he's just trying to get one of the charges thrown out. That's it. I really don't think he's going to be successful. That's all.
My subdivision is private. We clear all our roads. That doesn't mean I can get drunk and go tooling around my subdivision. People think that the evidence will come out at trial that this is generally accessible. None of the emergency responders, none of the guests, none of them had to pass any checkpoints, none of them had to go through any gates. This is an area that's generally accessible to the public under the statute.
All right, you get the last say so, Mr. Cruz.
Please, thank you. Your Honor, this is members only, private boat club. If somebody does enter that's not invited guests, it's trespassing. They can be arrested for a misdemeanor. You don't have to live down the street to be able to enter the club. If you're invited guests or a member, you can drive into the club legally. So living around the area, that has no relevance whatsoever. And then lastly is a driveway is private. And I understand the Court of Appeals case, but that was whether somebody had just driven recently the person's own house where he was drunk driving, and they upheld a conviction. But this is like, Judge, for me to show up at your house and pull up into your backyard and I've been drinking.
Don't do that.
I promise you, Judge, I would never do that because I really don't drink.
Okay.
So,
What kind of lawyer are you?
Diddy, on the other hand,
that is
she's
private.
drunk.
If you want to talk about earlier, Mr. Clovis or whomever was driving on public property, that's something different in inference. But this is strictly private, and it's members only. Thank you.
All right, well, the statute is crystal clear in my mind. You shall not operate a vehicle on a highway or another place open to the general public or generally accessible to motor vehicles, including an area designated for the parking of vehicles. That then is further elucidated by People versus Ray. There's no question this falls underneath the statute. This motion is denied. Go
Denied.
ahead with your next motion, Mr. Clovis.
The next motion, the toxicology.
Yeah, we're treating it, however, as a motion in limine.
Okay, Judge, well, all right. I actually need a evidentiary hearing, or I need a hearing to have the officer here to confirm what he had said. I presume this was going to be not an evidentiary hearing today on it, and I would ask any time next week, Your Honor, if you would, respectfully, if you could set it for a hearing.
Well, let me just go right to the point. All right, so I'm looking at your motion, and your motion says the people are going to attempt to have the blood test admitted at time of trial. They have the burden of establishing the foundational requirements. We all agree. We agree on what those foundational requirements are. Your motion then goes on to say that you strongly suspect that people cannot establish the foundational requirements for the admission of any blood testing results of the defendant. That's what your motion says. When we were here, I don't know if it was last week or 2 weeks ago, I said, well, I'm going to have to see some law. There was an amended motion, now an amended motion to suppress, but it says the same thing, that you strongly suspect that they can't establish the foundational requirements. That is what you're saying.
Dude.
That is, sum and substance is what you suspect.
They can't lay the proper foundation, and I would rather not have that at the time of trial to taint a jury.
Don't I need more than you telling me this is what I suspect they can't meet? Aren't you supposed to tell me something in this motion that says why you suspect they can't meet it?
Well, they have the burden. I don't have the burden of the foundation.
Mate, no.
Just like a Walker hearing, they have the burden. And a Walker hearing is heard on statements in Miranda. Prior to a trial, I don't want the trial to be tainted by hearing a foundation being laid. It turns out that it's an improper foundation, and the jury's already tainted by hearing it. It's almost the jury's accepting whether a foundation or not. And so it's only fair with 2 counts of murder that a hearing be scheduled. We have all of next week, respectfully, for a hour hearing with regard to the foundation. I don't believe the blood may have been drawn properly, but I don't believe the blood was preserved properly.
It doesn't even say that in your motion.
I guess, Judge, I'm informing the court that during the preliminary examination, the officer said that he never shook the preservative whatsoever, which he's supposed to do.
All right. Mr. Lorraine, your response.
People just stand by their response, Judge. It's a trial issue. If people can't lay their foundation during trial, Mr. Clovis, I'm sure, will object to that. The court will have to rule. And absent a Daubert hearing way in the past from today, I don't know how else the court handles it at this stage of the game.
Your Honor, may I respond?
Yes, always have the last chance.
Your Honor, that the vials, both vials, as the court's aware, have a powder in it for a preservative. The blood was put in there. The officer testified at the prelim, and it was never shaken. He is supposed to shake it by statute.
Shake.
Guideline. He was supposed to shake it because that preservative is what keeps it from being, instead of a .02, turns into a .18.
Well, why didn't you say that?
It's not shaken. And so he testified
Shake
to
your
that already in sworn
D-wee.
testimony. So that's just one item that he didn't do properly. I believe there's more than one.
All right. Well, again, this is as a motion in limine. Both motions only say that the defense suspects they might have a problem establishing foundational requirements. None of what Mr. Clovis is testifying here to is in his motion. You need something more. You can't have a trial run on the trial issue. If the foundation is not properly laid, just like any other objection, then the court's not going to let it in. For those reasons, the motion is denied.
Oh, big surprise.
If the court, with regard to the foundation, that be outside the presence of the jury prior to the testimony before the jury. In other words, that foundation is laid And then,
He's trying.
If the court admits it, then the trial continues in front of the jury. If the court does not
Wish he
admit it,
tried as
it
hard
has
as his
not been tainted
cholesterol
by
medication,
any
but
testimony. And it's
Yeah, he
excluded.
did.
I would ask that be done outside the presence of the jury.
Mr. Lorraine?
Well, Judge, the foundations for the blood, by my count so far, I might have 6 witnesses. So without a more definite
Righteous.
statement of what we're dealing with here, what we're concerned about having outside the presence of the jury, and also the blood result can't come in until the very end of that. So I don't know what taint Mr. Clovis is concerned about.
Which taint?
Because that taint wouldn't come until the very end of those 5-6 witnesses.
All right, I'm going to stick with my ruling. The motion is denied.
And so, Your Honor.
Surprise!
In front of the jury.
Yes, like any other trial.
Aw.
A couple of other issues that we need to deal with. The jury instructions are due on Tuesday. That's a deadline that must be met. It must include the witnesses you're actually going to call, and those should be in the instructions. The format must be suitable for the presentation to the jury. Also, I had pretrial services send the prosecutor and Mr. Clovis a copy of an email they sent to me regarding irregularities concerning the scram tether that Ms. Chidster is wearing. There was an obstruction on February 13th and an obstruction on February 14th. Both of those obstructions lasted 12 hours. Then there was a testing in probation that may have indicated the presence of alcohol. Do you like to address that, Mr. Clovis?
Certainly. Your Honor, we did do testing. We were notified. We went down to probation. It turned out, or at least some of the facts are, that, and the scram person that's here in the building, is that it was very loose. Her leg had swollen up because she had surgery. And so the scram unit was expanded by him, Jeff. And then the swelling went down, and it was very, very loose. And so he noted that the other day, a couple days ago, when she came in for this alleged violation or notice. And so he tightened it. He saw that it was very, very loose. So I think that's what may have caused it. Certainly, the most she wears is a nylon, and that doesn't affect it. But a loose mechanism on her leg certainly could have.
She wears nylons?
We don't know. But he did tighten it. It was quite loose. And he noted that. As to the alcohol reading, the actual alcohol reading was a .01. And I think it started off at a .018, thereabouts. My client and her husband.
That's not nothing, though.
Out of the house.
Basically, I mean, it's like
Couldn't figure it out. And we went down and met with her. It turned out that she was had this bottle of whatever flavored water.
whoa,
And
easy with that motion there.
That may have done it. But then, her husband can testify today as the strips. There's tea that she drinks, and the tea didn't show anything at all.
Tea.
But she drinks it with honey. She put the honey in, stirred it like she does, and put a strip in, and it showed faint alcohol.
Oh, please.
A .01 is a .02 and higher is illegal for a minor to have in their system.
Hang on, I'm
0.02 and
confused.
higher. Anything below .02, it's not illegal for a minor by statute.
I'm confused. .05 is what? No. For here in Australia, right? .05 is the legal limit for driving. .05. So .02 is it's not that low.
It's less than, or it's, he makes the point in a little bit, like for a minor, the highest they can be is .02.
Yeah.
So it's even less than what a minor is allowed to have in their system.
Okay, so
It's
.01 is 20% of like the legal limit for here.
Yeah.
Right?
Yeah.
So it's still like, because that's 2 standard drinks for a woman, right? So, yeah. So therefore, it's 20% of 2 standard drinks for a woman.
Okay.
Yeah. So therefore, if 2 shots, 20% of 2 shots.
Yeah.
Yeah. So it's like, it's not nothing. Like, you wouldn't get it out of a cup of tea with some honey and some some kind of additive.
Well, unless the bees were really drunk, I don't know.
Legal limits .02 here. You're in Norway, aren't you, Emilsland?
Really?
Are you or
Interesting.
yeah, I know you're somewhere in Europe. Sorry, I couldn't remember. .05 in Alberta. You're in trouble.
Well,
Yeah, I mean,
you're already in
okay.
trouble if you're in Alberta, but just kidding.
Not considered alcohol under the influence. So I don't know what occurred, but I know a .018 is beyond low. It's extremely below low.
I don't know. I think that's pushing it.
Judge, the results, I do not believe strongly. I do not believe that it's an indicative of having alcohol in her system or consumed any alcohol whatsoever. Again, if it was a .03.
All right, when we say again, we're just
Again.
saying the same thing. I got what you said.
I like it. Just
I do agree with you that the alcohol is low. There's a lot of things that could factor into that. I can't necessarily or wouldn't necessarily take any action with respect to that. As to the obstructions are lasting 12 hours. So they're loose for 12 hours and then they somehow tighten themselves up again. I have some real questions about that, but nothing definitive. I'm just putting Ms. Chidster on notice regarding any of the obstructions regarding this, and I'm directing her to go immediately from leaving this court down to pretrial services and have them test her again. If the tests are fine, we'll see you a week from Monday. If not, we'll see you later this morning.
And Judge, if people could speak to the bond violation just briefly.
Sure.
People's understanding of it is that pretrial services ran into these issues.
why does he stand like
Prepared
that?
a report on them, but didn't believe that they would be able to meet their burden in a bond violation hearing. People understand that that's pretrial services position.
very
People just want to
defensive.
put on the record that if there is a
Yes.
supported bond violation in this case, particularly one related to alcohol, people are going to be vehemently moving for
Or
remand.
he's,
Understood.
Should
he's
have a
the
little.
offense.
Anything else that we need to talk
You should
about?
have a little more confidence.
All right, thank
He
you.
should. Okay, so now this he did a press interview after.
It really isn't. What it is,
Oh.
and I expected it, it's a motion denied at this time. They still have to lay the proper foundation at the time of trial. So they can't just come in and say, this is your test result. They have to show that they drew the blood properly, they preserved the blood properly,
Right.
and they tested it properly. And if they don't do that, then it's not allowed in. At least under the law, it's not allowed in.
But correct me if I'm wrong, you wanted to have this thrown out beforehand, right?
That's
Before the trial.
well, I wanted the blood test results before trial, and the judge denied it. The judge has full discretion on rules of evidence of how it would be heard, and that's what he ruled, and that's what we live with, and we continue on.
If that was your interest, I heard the judge talking to you about potentially bringing witnesses in that you would have support the contention that you're making. Why wouldn't you, if you didn't want it in front of the jury at all, why not do that with witnesses now?
The judge is not allowing it.
Because of the filing timing, or?
I told the judge excused the filing timing, finding good cause that because of the expert that was retained and the medical records that were just received 2 weeks ago, if that, I couldn't prepare a motion. I didn't know that there was something that was in error in addition to the officer testifying as prelim. So the bottom line is the judge found good faith that I couldn't have done it at that time.
That's not what he said.
The judge is allowing it at the time of trial. What do I think that does? It taints the jury.
Taint.
It just taints the jury.
Taint.
The jury aren't attorneys. The jury aren't scientists. They're not toxicologists, and it taints the jury. And given that
Well, that's a different
4
thing.
out of 5 motions
Mavka.
have been denied, I expected this one to be denied.
He should put in a.
Why do you think it taints the jury? I mean, they're going to have to listen.
Okay, so Mavka, he should be putting in a motion for change of venue then, if that's the case. And I mean, has he? I don't have the documents. I don't think he has. I think that would have been documented. That, I mean, it would have been, sorry, it would have been on in the media, because I've gone through all the media reports and I haven't seen anything about a change of venue. You might be right that it'd be very hard to find a impartial jury in Monroe County. everyone in Monroe County, I would think, would know about this and would feel very biased against her. But this thing about the blood alcohol level, unless he can suppress her body cam footage, at her talking to that thing I showed earlier, her talking to the police and saying flat out that she feels like she's not capable of driving, straight after plowing through that wall, unless he can suppress that, I think she's screwed. I think it makes no difference whether or not someone screwed up the blood test. I mean, she really screwed herself there, unfortunately.
Listen to all the testimony, the cross-examination, all of this evidence that's going to come out during the trial.
The foundation, if the judge wants to proceed that way and have the foundation requirements come out at trial, they will hear it. If he chooses to follow my request, and that is have a separate hearing during the trial outside of the presence of the jury, meet the foundation, then bring the jury back in, and then continue the trial. And if you ask, well, what's wrong with just the jury hearing all of this? Because jurors sometimes don't have the training, the certification, or once the result is out, sometimes they'll just think that that's the result. What is this attorney trying to do something with how the foundation was? The judge allowed it in. He said the numbers. That's good enough for me.
Yeah.
And I did ask the prosecutor. I said, are you going to bring up the .18 during the opening statement?
Yeah.
Because that really taints before evidence is allowed. You're telling the jury things and you're already tainting them. And he said that he will not mention the blood alcohol results during opening argument. And
that's nice of him.
The jury pick, which I thanked him.
Thank you for not tainting.
Property. You know, what does it matter if it's private property or not? I mean, you still can't drive around and, under the influence or have a seizure and run into a building and kill kids. It doesn't matter if it's private or not.
The statute specifically states that it has to be public property that you're operating a vehicle under the influence or open to the public. This property was private. It was membership only. It would be trespass if you entered it. This wasn't a Burger King or McDonald's.
You can't have it your way.
The statute, and we're following the statute. I'm not making up the law. Statute says that for you to be arrested for drunk driving and to be charged, it has to be public property. In other words, you're drinking and you're going up and down your driveway. That's not drunk driving.
Wow.
You're driving around your backyard or your field or your acreage. That's not drunk driving. When you enter the public right-of-way, then that's drunk driving. That's what the statute says. I didn't make it up.
But the law is you can't drink and drive.
Right, but that doesn't, you can drink and drive if it's private property. I know that's sort of tough to, and what you're really thinking is this. What you're actually, I believe, thinking, and you're sort of
oh, don't tell her what she's thinking.
Is that for the two charges of murder too, if you're reckless and dangerous and things like that, then you can be charged with murder too. Now that's whether it's private property or not private.
Yeah.
But if you're going to charge them with operating a motor vehicle while intoxicated causing death or causing great bodily injury, then it's got to be on public property. Because you'll look at it, and I understand where you're coming from, you're saying, wait a minute, does that allow somebody to get drunk, and if they are drunk and drive around and kill people? No, it doesn't. That's where you can charge somebody with a homicide or a murder charge. But you can't charge them with driving under the influence on a public road or a public place. That's what the statute says.
And your client has to clear a blood test yet again today, correct?
A urine test, yes.
Just to make sure because of the...
Just confirm. And again, remember, it was a .01. Even a child can have a .01 because your body itself makes up alcohol.
Even the children that my client ran over could have a point zero.
My God, it's not a good example.
And underway we go, or
that's correct. Right now, the
He's
Court of
not-
Appeals,
he's not making
on
himself
February
more
14th,
likable.
Valentine's Day, they issued their order that said that go ahead and go to trial, and that we're not going to hear this case with regard to the adjournment. We are in the process of appealing to the Michigan Supreme Court for the adjournment because our material, our main witness,
Marshella
is not
has
available
dollars, does
right
she?
now because he's under arrest
club
and
she's part
charged with
of.
35 counts
So?
of criminal enterprise.
I imagine that's money.
And that's her doctor, right?
Dr. Garg, G-A-R-G.
And he's the one that cleared her to drive.
Oh, yeah. He said 6 months, and you go ahead. He didn't say, come back in. He says, you're good.
6 months and 6 drinks. You're good.
He's following doctor orders.
He's not exactly the most credible witness. No offense.
No, I agree, but
that's the point, sweetie.
There's no medical records, nothing that says that you cannot drive beyond those 6 months. And she waited 6 months and 3 weeks.
Okay, so let's
And
just
he
talk
never
about
also-
that for a second, right? So she was being seen by this doctor who's now indicted, correct?
Yes, he's in
Yeah.
hot water.
He's in big trouble because he was running a pill mill allegedly, right? And he's the one who gave her drugs for her seizures, and he would have been called as a witness in her trial because he supposedly gave her the green light, no pun intended, green light to drive after 6 months since his last consultation with her. But I thought he saw her that day. Whatever. But apparently he told her it was okay to drive. So aside from any alcohol, and let's just give this lawyer and his client the benefit of the doubt for one moment.
If we must.
We must. And go, okay, so let's assume that she wasn't 0.18, that she was not that drunk, because she said she only had 1 glass of wine that day. That's what she said, right? So let's assume that she was under the influence of drugs rather than alcohol. And maybe she had a seizure too, I don't know. Right, but let's say she was under the influence of drugs given to her by this doctor who was running a pill mill and was some sort of quack. Right? Now, he's indicted and he's pleading the fifth. Right? So he can't be a witness at the trial. So this lawyer has argued to the court to please postpone Marshella's trial because of the situation with the doctor. And judge has gone, nah. Sorry. So that could be an appellate issue for Marshella, I suppose. Because, I mean, I guess. But, I mean, if it comes down to it, she said flat out to the cops, in terms of, like, they asked her, how drunk are you? Like, they said drunk, didn't they? In terms of 1 to 10, like...
completely sober and then
sober,
10,
yeah, like...
not able to drive.
Not able to drive.
She was a 7.
7. So, like, she incriminated herself big time, regardless of whether or not there was a doctor who was giving her drugs. So, I feel like the judge has covered his ass.
But you and I talked about this last time.
But
She had a seizure in March and went to the hospital, and she had another seizure while she was at the hospital. She was hospitalized for a total of 10 days, 6 at one hospital, 4 at the other. That was March. This happened in April.
Right. Why didn't the hospital and the doctors at the hospital say in their records and to her, do not drive? do not operate a motor vehicle.
Because they refer you to your primary care physician. This has happened to me before.
Okay, well,
And I couldn't drive for 6 months.
I understand. Also, the primary physician should have sent by law to the Secretary of State her medical condition, and they automatically, without a hearing, suspend it and then say, give us a hearing in the future when you have medical approval to drive. It wasn't done.
Thank you.
You're welcome.
Thank you.
Yeah. So, do we have to watch this again? Actually, yes. Boom. All right. Okay. So, yeah, Majestic Wildfire, you're right. The medication bottles tell you not to drive.
Yeah.
And absolutely that would be brought up by the prosecution as well. So, even without being able to bring that doctor in as a witness, you could potentially bring in the fact that he's been indicted. Couldn't you?
Yeah.
Yeah. Could
You could probably find a witness to testify to that.
Yeah.
Now, I don't know if he'd be able to.
or
bring in
not,
his-
because there's bad acts that haven't been
No, I don't think that matters.
proven.
I don't know if he'd be able to like bring in the doctor's notes about her if he can't testify.
No, you wouldn't be able to bring in the doctor's notes. No, I'm talking about prosecution. Could prosecution... No, I suppose not.
Prosecution could grant him immunity, but they won't.
Yeah. Anyway, it doesn't really matter because, yeah, I mean, the medication bottles tell you not to drive, and the state could bring that in. The state could absolutely bring that in. Yeah. So if the defense tries to say, well, she had doctor's orders that she was able to drive, then the state could be like, well, hello, are these the bottles that were found in her house? Is this the label that you see on the bottle? What does the label read? I'm all for it. She needs to have a fair trial, and all of this stuff needs to come out. I think she's absolutely screwed, and she needs to take a plea deal. Because she's very old. She's at 68, nearly 70. She's got 2 counts of, is it murder 1 or 2?
Murder 2.
2. She's probably going away for at least 20 years. So I think she's going to prison for the rest of her life. Like, that's it. It's over.
Yeah.
Who actually reads pill bottles? Well, not me generally. But I also, I don't see any excuse for her getting into a car. It's 500 feet down the road.
Yeah.
Like, it's not even, she's not 48. She's not. She could have stumbled down the road.
Yeah.
And she even told the cops that she doesn't feel like she should be driving right now. That was the dumbest thing to say.
Unless she meant like after the accident. I mean, she could have been disoriented.
Oh my
I'm just
God.
devil's advocate. Just saying.
Yeah.
But
I have like 3 different meds. I can't drive or operate heavy equipment, and it's all over the bottle pack. It's not the doc's fault, no matter how bad he was. Yeah.
it's pretty tiny here in the U.S., to be honest. It's a pretty small warning.
There are some instances where the doctor can override that warning, like if you have like a tolerance to it or something like that. But like that would be in her medical records, and in which case the doctor would testify to it. But in this case, the doctor's not testifying.
Yeah.
Because he's indicted for running a pill mill.
Yeah.
So he's not exactly the best witness for the defense, right?
Yeah.
No.
Probably not.
No. All right. So I'm interested in this case. I mean, it's a bit of a niche one, but
Yeah.
I just have been interested in it since it started. And also, I don't know how free David is, but he may be able to go to the courtroom. Mavka, it's near you, right? So you may be able to go to the courtroom too if you're interested.
The next hearing is Monday.
Is
for
it?
the trial? Yeah.
Oh, okay, sweet. So yeah, I'm interested in continuing to cover this one. So yeah, hopefully if more stuff happens. When's the trial? The trial was supposed to be soon, wasn't it?
The
Like
Monday,
June?
3rd.
What, the
March
actual
3rd.
trial's supposed to be the 3rd?
Yeah. Next.
All
yeah.
right.
Jury selection's Monday.
Okay.
Yeah. 7 days.
Sweet.
Yeah. So we got to get
Let's
ready.
go.
Assuming it goes to trial. I mean, she could still plead.
Okay.
But
cool. Let's watch the trial.
Yeah. Should be interesting. Okay. I was wondering why you weren't like reaching out and getting all ready
what?
for it.
Oh,
The
I
trial.
don't know. You didn't tell me.
I thought you knew. Sorry.
I sleep during your days.
Okay.
Unless you want to do it, I don't care.
We'll see. Figure it out.
All right, we'll talk about it. All right. I already bought mushroom spares to meet up with my what?
Amigo there to plant.
Monday, hey? Cool.
Yeah.
It shouldn't go for too long. It should be pretty quick.
3 days, if that. 4
Yeah.
maybe.
All right. Cool.
The long end.
I mean, we could run the trial, or we could just do like recaps of the fun bits. Not that it's going to be fun.
Yeah, I was gonna say it's a poor choice of words, but I understand.
Well,
what
I
you
mean, there's going to be a lot of boring shit.
Yeah.
There's gonna
Although
be a lot
I
of-
think there, well, I was gonna say there will be good lawyering, but I'm not too confident about that anymore.
What?
There
There's
was
going to be some funny lawyering.
there's the, in theory, there's the potential for good lawyering to happen from the defense. I just don't have a lot of faith.
I don't have
in
much
the
faith in this dude.
No.
Clovis is. He's
Well,
a Clovis.
Maybe he's a late bloomer. Maybe he'll really sprout into his own during sentencing.
Maybe. Yeah. No, there is not. All right, we'll have a talk about it. I'm not sure. I'm interested in it, but then I'm like, maybe just recaps.
Well,
Maybe
let's
just
talk about it.
All right, cool. Yeah, and yeah, guys, tell us what you think. Tell us what you think, whether you're interested or not. Maybe I should have called DUI guy and buckle up.
Maybe we can see if he's available.
For sure. All right, cool. Thanks for watching, guys. I really hope actually she goes to prison. I think that she deserves it.
We'll see.
Yeah, but I think there's no point in hoping it will happen. So there's kind of no question about it. This is a done deal. So, all right. Thanks everyone for watching, and I'll see you guys later. Time for this song.
Her name was Ella. She was an Aussie. She was a fake lawyer from the future. She got on YouTube and made some live streams. The co-host is Dolly and she dances sometimes. The words are always so loud and because she's an 803. To the attention, excited.